Thank you for joining us and welcome to this webinar session, Moving Mountains, How You Can Help Reauthorize the Violence Against Women Act. My name is Suzanne Green. I am the Outcomes and Outreach Coordinator for NCADV, and I'm joined today by Pat Silva, Business Manager for NCADV, and Gretchen Shaw, Deputy Director of NCADV. Take a moment to locate the questions box in your control panel, and this is a quick reminder to download the handouts. A copy of the PowerPoint and all handouts can be found in your control panel under handouts. If you have a question for any of the panelists on today's webinar, please submit anytime via the questions box. This webinar is being recorded. We will send it to you along with the handouts and a follow-up email, and at the end of the session, we will have a quick survey for you to fill out. Before we begin today's panel, we have a quick poll. Okay, once everyone's taken some time to fill that out, we'll show the results. Give a couple more minutes on that. And okay, we can look at the results and see who's here today. All right, thank you for participating. At this time, I would like to introduce our first presenter.
She was going to introduce me. Should I just jump in?
First presenter today is Dr. Angelo McClain. He's the Chief Executive Officer of the National Association of Social Workers, a membership organization that represents over 120,000 social workers and works to shape public policy and advance the role of social work in affecting social change. Prior to joining NASW in 2013, Dr. McClain was a commissioner for Massachusetts Department of Children and Families and oversaw a workforce of 3,500 employees to address reports of abuse and neglect for the state's most vulnerable children. Partnering with families to help them better nurture and protect their children, Dr. McClain grew up in Texas and is a distinguished alumnus of Cal Farley's Boys Ranch. He holds a Bachelor of Science in Social Work from West Texas University, Master of Science in Social Work from the University of Texas at Arlington, and a PhD in Social Work from Boston College Graduate School of Social Work. For today's presentation, we're going to be doing an introduction to VAWA, authorization status, HR 1585, homicide reduction, prevention, housing for survivors, special tribal jurisdiction, protections for LGBTQ survivors, economic security for survivors, and speak about the August recess and engaging with members of Congress, and then we'll have questions at the end. So at this time, I would like to introduce Gretchen Shaw. Gretchen Shaw currently serves as the Deputy Director of the National Coalition Against Domestic Violence, where she has worked since moving to Denver from Alabama in 2000. Her experience reflects a background of developing and directing programs and projects, grant writing and research, event planning, administration, and management. In collaboration with the Feminist Women's Health Center and the National Organization for Men Against Sexism, she helped research, write, and produce Exposing Reproductive Coercion, a toolkit for awareness raising, assessment, and intervention, and directed the development and production of Take a Stand for Healthy Relationships, a teen dating violence prevention curriculum, a resource on teen dating violence and healthy relationships targeted towards school educators that is free, easy to use, and engages youth in critical discussions around the topics of teen dating violence and healthy relationships.
Great, thank you all for having me. I think we'll go, do we need to go back to Dr. Angelo? So Dr. Angelo, I know that we introduced you and then didn't give you a chance to speak. We wanted to see if you had a few words to share and needed to say anything.
Hello, this is Dr. McClain. I did have a few things I would like to share.
Great, go ahead.
I want to welcome everyone and their participation in this webinar. Moving mountains, and not to think that moving mountains is intractable, but we want to move the mountain and get the Violence Against Women's Act reauthorized. It's a very important piece of legislation that can help us in our work to reduce domestic violence and inter-partner violence in our country. And we all know that this is an issue that cuts across all different social, economic, and racial groups, and it's a problem in all of our communities. And we know in order to address this public health issue that we need legislation that provides the resources that are needed in the local communities to combat this issue. I had the privilege while I served as a commissioner in Massachusetts to be the co-chair of the White Ribbon Day campaign in Massachusetts back in 2012. And that was really an effort where men took a pledge to end sexual assault and domestic violence against women. And in taking that pledge, we pledged that we would get 5 other men to take the pledge, and to really understanding that men have a role in ending violence against women. So I want to just make sure that folks understand the importance of this, understand that if you are a constituent, you are a citizen of this country, and you need to use your influence. You do have influence. You need to use your influence to urge our legislators to take the appropriate steps to reauthorize the Violence Against Women's Act, so we can be on that road towards reducing, curbing, and eventually eradicating domestic violence from our society. So I thanks for the opportunity to be able to give this welcome, and I'll hand it back over to our moderator.
Thank you so much, Dr. McClain.
All right.
Go ahead, Gretchen.
So again, thank you all for being here. I'm Gretchen Shaw, and I'm the Deputy Director of NCADV. I'm going to take just a couple of minutes to talk to you about what VAWA is, its importance, and its impact. I'm sure many of you are very well versed on this piece of legislation, but in case you're not, this will give you some insight. So the Violence Against Women Act, currently HR 1585, is one of the pillars of the federal response to domestic violence, sexual assault, dating violence, and stalking, which we term the 4 crimes. Since 1994, when VAWA was first passed, the rate of domestic violence has decreased by 63%. So as you can see, it's incredibly impactful. VAWA provides grants to transform law enforcement and the legal system's response to the 4 crimes by bringing together victim service organizations, law enforcement, community-based organizations, prosecutors, judges, and other stakeholders to develop coordinated community responses to these 4 crimes. VAWA funds the prevention through a number of grants that approach it from different angles. It funds services to victims of the 4 crimes, including crisis intervention, domestic violence and sexual assault advocacy, shelter services, legal services and advocacy, housing for survivors, community-based interventions, and many other important services. It also funds population-specific programs, including programs designed to meet the needs of communities of color, older adults, rural communities, people with disabilities, young adults, LGBTQ people, and others. It also provides critical legal protections to all survivors. So why is VAWA important, and what impact has it had? So VAWA essentially has transformed America's response to these 4 crimes. It certainly strengthened victims' involvement in the criminal legal system, and including their likelihood for reaching out for help. So when victims receive that help, the likelihood of their abuser physically harming them or killing them decreases substantially because they have support, and their abusers are often held accountable. So VAWA funding prevention program has been empirically demonstrated to reduce sexual violence. VAWA funded court and law enforcement reforms have improved access to safety and justice for survivors. It's increased offender accountability and has decreased recidivism. Specifically, between 2014 and 2016, VAWA funding provided more than 1 million victim services for survivors of the 4 crimes, including almost 2 million shelter nights, 600,000 hotline calls, victim advocacy for almost 300,000 unique individuals, and legal services for almost 100,000 survivors. Every 6 months in that period, VAWA funding served an average of 112 primary survivors and their children. Additionally, VAWA saves money. A 2002 study found that in its first 5 years, VAWA saved $15 billion in averted costs. It's ended impunity for domestic abusers who prey a lot on Native women on tribal lands. And VAWA protects diverse survivors, including the LGBTQ survivors, older adult survivors, survivors with disabilities, immigrant survivors, Native survivors, and others. So as you can see, the results are clear that the reauthorization of VAWA is absolutely critical to the safety and well-being of victims of violence. So now I'll turn the slides over to Rachel Graber.
Thank you, Gretchen. Now I'd like to introduce Rachel. Rachel Graber is the Director of Public Policy at the National Coalition Against Domestic Violence, where she leads NCADV's legislative efforts. She is also among the creative forces behind Disarm Domestic Violence, a project providing state-by-state information about domestic violence prohibitors, how they impact survivors seeking safety, and state-specific public health data. She co-chairs the Firearms and the outreach committees for the National Task Force to End Sexual and Domestic Violence. Good afternoon, Rachel.
Hi, thanks, Suzanne. So as Gretchen mentioned, VAWA's authorization expired at the end of 2018. And so I just want to talk a little bit about what that means, because a lot of people were making some untrue claims. That domestic violence and sexual assault programs would stop getting funded, that abusers and sexual predators weren't being prosecuted. So there are 2 different congressional processes related to grant programs, right? The first is authorization, and in this process, Congress authorizes itself, allows itself to spend a certain amount of money on a certain grant program. Usually these grant programs are authorized for 5 years. And then Congress needs to look at them again and make sure they don't need any tweaks, right? The other process is appropriations, and this happens every year, and it's where Congress decides how much money to actually spend on each grant program that year. So most grant programs, like I said, need to be reauthorized every 5 years, and VAWA was last authorized in 2013, so its authorization has lapsed. But Congress understands how important VAWA is, and they know that we're working on a bill. Sorry, the lights turned off when I don't move enough. Oh well, that's okay. So they know that we're working on a bill, so they'll keep funding it like they did between 2010 and 2013 when VAWA was reauthorized or unauthorized back then as well. So just really quickly, only grant programs need to be authorized. The underlying law doesn't expire. VAWA is unauthorized, but interstate domestic violence and sexual assault, they're still crimes. Tribes that are exercising special jurisdiction, special tribal jurisdiction, they still can exercise that. You know, the provisions that don't involve money aren't impacted by VAWA's authorization. Of course, that doesn't mean that we don't need to reauthorize VAWA. It's really important for a variety of reasons for it to be in authorization. But what it does mean is that we don't have to settle. We don't have to accept a VAWA reauthorization that we're not okay with, that doesn't meet the needs of survivors. We're not desperate. Advanced slide, please. Thanks. So in early April, the House of Representatives passed HR 1585, the Violence Against Women Reauthorization Act of 2019 with really strong bipartisan support. We did work very closely with Representatives Bass's and Fitzpatrick's office to ensure the bill was as strong as possible, and it was based actually on extensive outreach to advocates like yourselves and other experts. When I say we, I'm talking primarily about the National Task Force to End Sexual and Domestic Violence, which is a collaboration of about 27 national organizations that do work at the federal level, and then bringing some organizations with expertise in certain areas who aren't part of the National Task Force as well, to make sure that we have a whole breadth of expertise when we're looking at reauthorizing this important legislation. Unfortunately, we passed this great bill in the House. Senate does not seem all that excited or interested in taking up the House bill. And so we are kind of working through a process in the Senate to help them write their own bill. And our ask from the Senate is that their bill is substantially similar to HR 1585. HR 1585 is over 200 pages long, so we're not going to be able to talk about everything that's in it, but we did want to highlight a couple of important areas. First of all, there's no way we will accept going backwards. As you see, no rollbacks. We've gained a lot over the past 25 years, and we are only going to move forwards. That means we maintain and expand protections for vulnerable communities. You can see some of our other priorities on this slide. We're not going to talk about all of them, but it will just give you kind of a little taste of some of the things that we're looking at. So like I said, we are working with the Senate to develop their bill right now, and we need some help from you guys to really put the pressure on them to introduce a bill that's strong and that meets the needs of victims and survivors. Advanced slide, please. Thanks. All right, so moving on to the substance of the bill, I can just tell you from the NRA hates it. The NRA, the National Rifle Association, they officially opposed it. They pressured lawmakers to vote against it, and they spread lies about both what's currently in law and what's actually in the bill in order to try to kill the bill. Of course, both lawmakers on both sides of the aisle recognize how important VAWA is, and it did pass the House with strong bipartisan support. But the NRA, they hate HR 1585 because it does contain important provisions to keep guns out of the hands of adjudicated abusers. And here at NCADV, this is one of our top priority areas, and I know that's the case for some of our other presenters today as well. So we know that abusers with guns pose a unique risk to their communities and to their victims. Abusers use guns as a tool of power and coercive control, and abusers who possess firearms are more likely to perpetrate severe physical harm than abusers who don't have access to firearms, even if that harm isn't related to the guns at all. So most domestic violence homicides are committed with guns, and when a male partner has access to a firearm, it increases the risk of intimate partner femicide fivefold. So, we know that firearms are dangerous, and actually we've seen recently an increase in the number of intimate partner homicides committed with firearms, even though the overall intimate partner homicide rate has gone down. So recognizing the unique danger posed by abusers with firearms, the very first VAWA back in 1994 prohibited respondents to final protective orders that have certain terms on findings from possessing firearms. In 1996, recognizing that most misdemeanor domestic violence convictions are actually for felony level violence, Congress then also prohibited domestic violence misdemeanants from possessing firearms. We call these prohibitors. Somebody's prohibited from having a firearm as a prohibitor. Due process protections are written directly into the law, and both of these prohibitors have faced court challenges and been upheld. So of course, back in the mid-1990s, lawmakers didn't really have a sense of the full scope of domestic violence, and they assumed domestic violence was only confined to certain intimate relationships. Dating violence wasn't didn't even become a federal crime until 2005. So domestic violence prohibitors, as you can see here on the slide, they only apply to current or former spouses, current or former cohabitants, and abusers who share a child in common with the victim. So, you know, there's this huge gap for people who are in dating relationships, you know, and we know now that about half of intimate partner homicides are committed by dating partners. And as people date longer, they wait to move in together, they have children later, that percentage is just going to increase. You know, and we also know that young people are at the greatest risk of experiencing intimate partner violence. About 80% of domestic violence calls to law enforcement are actually for dating violence, but the federal law doesn't prohibit adjudicated dating abusers from possessing firearms. So forward slide, please. So HR 1585 closes that, people call it the boyfriend loophole, the dating loophole, and it also closes a couple of other loopholes too. So it prohibits adjudicated dating abusers and adjudicated stalking misdemeanors from possessing firearms. And as you can see on the slide, I do emphasize adjudicated because certain parties have been claiming that being accused of domestic violence or dating violence or stalking would be enough for a person to lose their firearms access. And that's not true at all. Obviously, you know, a court has to be involved throughout, so that a court has to convict someone or issue a protective order for the prohibitors to apply. And again, you know, there are due process protections written right into the text of HR 1585. It contains an important technical fix to address some outlying court decisions by specifying that misdemeanor domestic violence prohibitor applies to people convicted in municipal courts and prohibits respondents to ex parte protective orders from possessing firearms temporarily, again, with robust due process protections written right into the text. Some states have closed these loopholes in their state laws, and a number of researchers have assessed the effectiveness of these laws, and the data is very clear. It shows that these changes that we're asking for do save lives. So before we move on, I do again want to address quickly some of those lies spread by the NRA. First of all, as it says on the slide, HR 1585 doesn't contain what they call red flag laws. We prefer the term extreme risk protective orders. And I'd be happy to talk another time about why extreme risk protective orders really aren't appropriate in most domestic violence cases. But for now, just suffice it to say that HR 1585 doesn't contain any ERPOs. NRA also claims that this is a massive expansion of firearms prohibitors, but as I said, it's really just kind of updating anachronistic definitions and things like that. They're also trying to claim that these changes are overly broad and that someone who goes on one date could lose their firearms. Of course, I do have some general concerns about someone who goes on one date and assaults the person they're dating. But that kind of situation isn't covered here. Dating violence is very specifically defined. You know, same with stalking. They're claiming that stalking could mean just sending repeat text messages. Obviously haven't read the bill because again, stalking is very clearly defined and it has to cause a reasonable person to fear bodily harm. So unless you're sending repeated text messages with threats, that wouldn't trigger the prohibitor. Forward slide, please. So HR 1585 also contains provisions to ensure current federal and state laws related to the intersection between domestic and violence and firearms are enforced. Obviously, enforcement is a vital component of protecting survivors and communities from armed abusers. So a lot of courts will require prohibited abusers to surrender their firearms to law enforcement, but research shows that the court order to surrender the firearms is actually not very frequently enforced. So HR 1585 adds purpose areas to STOP and ICJR grants, so those are kind of the two biggest grant programs in VAWA, to allow jurisdictions, if they want to use their VAWA funding to develop and implement policies and protocols to safely recover contraband firearms from abusers, to store them, and then when the person is no longer prohibited, and you know, if a protective order expires, for example, to return the firearms. And again, research shows that state laws that require abusers to get rid of their firearms, they actually reduce the rate of intimate partner homicide. So moving on from that, HR 1585 also requires the FBI to notify local law enforcement when an abuser tries to purchase a gun, but fails a background check because their status as a domestic violence misdemeanant or as a respondent to a protective order. We know that when an abuser is trying to buy a firearm, it's potentially a sign of escalation. And so local law enforcement needs to be aware of this so they can keep an eye on the situation. It also requires cross-deputization of local law enforcement as ATF agents and local prosecutors as special assistant U.S. attorneys to improve cooperation at the federal, state, local levels, and to make sure local law enforcement can call on the federal government when they have situations they can't deal with on their own for whatever reason. So that's about it for firearms. Thanks, Suzanne.
Thank you, Rachel. At this time, I'd like to introduce Deborah Rosenblum with the Jewish Women's International. Deborah Rosenblum is JWI's Vice President of Programs and New Initiatives, responsible for directing and implementing JWI's work to end and prevent violence against women and girls. For over a decade, Rosenblum has led JWI's innovative efforts centered on engaging the Jewish and interfaith communities in advocacy and resource development, empowering men and boys to be allies, advocating for anti-violence legislation, and collaborating with diverse organizations. She is currently directing JWI's second OVW grant to engage men and boys as allies. Deborah leads the Clergy Task Force on Domestic Abuse in the Jewish Community and the Interfaith Coalition on Domestic and Sexual Assault. Under her leadership, JWI co-chairs the Firearms and the outreach committees for the National Task Force to End Sexual and Domestic Violence.
Thank you. Next slide, please. Thank you. So as you all know, prevention is incredibly important if we're going to stop this cycle of violence and help the youth who are so impacted by it. We need to start early, and VAWA seeks to do that. There's prevention grants serving youth from ages 0 to 24. We know that young people between the ages of 16 and 24 experience the highest rates of domestic and dating and sexual violence, but children at home as witnesses, children are impacted in all sorts of ways, and we know that that the violence starts way younger than 16, and that's what these grants really seek to do. In 2005, there were separate grant programs to address the different needs of the different ages and the different services that needed to be provided. And these were then consolidated in the 2013 VAWA, which consolidated 7 separate grant programs into 2. And the distinctions between them, although there's 2 separate authorizations, the distinctions between them are that one of them is really kind of coordinated community responses, which provides, we can go to the next slide, please, which provides training and resources for formal and informal educators, for first responders, for training judges, for social workers, for counselors, for anybody who really interacts with youth and children, and to serve their specific needs. And then the second set is prevention grants, really essentially to help youth understand and promote healthy relationships, engage men and boys as allies, and the other important work that will end these horrific crimes. The new VAWA, the HR 1585, despite pressure from OVW to further consolidate these grant programs, maintains these grant programs within the Consolidated Youth vehicle. And there's 2 of them. It's called Choose Youth or Smart Prevention. The really critical thing is that we are seeking, and the HR 1585 provides authorization for significantly increased funding for these programs, and really mostly for the rape prevention education. In this era of @MeToo and everything that we know how important rape prevention education is. And there's actually a waiting list for programs to be delivered. And what we are asking for, and what we hope that the Senate will also agree with is that we get this increased funding so that more and more of our youth can be served and more services can be provided to them. And that's it. I think there's one more slide, but yeah. Thank you.
Thank you, Deborah. At this time, I'd like to introduce Monica. Monica McLaughlin is with NASW. She works to improve federal legislation and increase resources to address and prevent domestic violence. She leads and co-chairs various national coalitions, educates Congress, implements grassroots strategies, and engages various government agencies to ensure that addressing domestic violence is a national priority. Monica has led national appropriations efforts to secure record federal investments in programs that address domestic violence and sexual assault. Monica also directs NASW's housing policy. Building on her housing policy work, Monica leads NASW's collaborative approaches to housing for survivors, a multi-agency technical assistance consortium designed to improve survivors' access to safe and affordable housing. Good afternoon, Monica.
Good afternoon. Hi, everybody. So yes, I'm Monica. I'm with the National Network to End Domestic Violence, and we represent the 56 state and territorial domestic violence coalitions, and of course, their local programs and the survivors that they serve each year, with a mission to end violence, to create a political environment in which violence against women no longer exists. One of the most important ways that we work on that is through housing. From our perspective, housing is safety. For so many survivors, access to safe, affordable housing is the difference between having to continue to endure abuse or sort of starting a life over and rebuilding. And you all know that really well from your work as well. You know, we hear from advocates, we hear from survivors themselves that access to safe, affordable housing is critical. It's one of the most highly requested services, and yet many survivors are unable to access it. We learned that from report after report that survivors say that they can't access housing, and that puts them in a very precarious situation. And in fact, we know that if you experience housing insecurity or homelessness, you're more likely to be abused as well. And so it's critical that the Violence Against Women Act address this intersection of housing instability and facing domestic or sexual violence. So we have a number of provisions in the Violence Against Women Act that create a legal framework for survivors to enact their rights in public and assisted housing. So take you back a number of years to 2005, when we were faced with a problem that survivors in public and assisted housing, and also the private rental market, but we addressed it in public and assisted housing, would face eviction based on the criminal and violent actions of their perpetrators. So a survivor would be abused or assaulted and then would receive an eviction notice from their landlord that said, someone in your direct control has violated the rules or been violent, and therefore you're going to be evicted. So obviously that was incredibly egregious, that a person would face both violence in their home and then get an eviction notice based on that violence. So we worked across the aisle and with housing industry providers and the U.S. Department of Housing and Urban Development to create a prohibition against that discrimination so that survivors wouldn't be evicted based on the criminal actions of their perpetrators. And also, they wouldn't be denied further housing based on their record of having been evicted for domestic violence. And so those were landmark protections included in 2005, and we've worked since then to get regulations issued around those, the 2005 law, and then work to implement it as well. Having learned a lot from 2005, regulations, implementation, looking at, are survivors accessing their VAWA rights? How does it work or doesn't work? We were able to craft a new proposal in VAWA 2013 that would expand survivors' access to housing. So what we did in 2013 was create an emergency transfer process. That meant that a survivor accessing subsidized housing from the federal government could move from one subsidized unit to another subsidized unit without ever having to become homeless. We also expanded at that point the types of housing that were covered by the Violence Against Women Act. Again, still federally subsidized housing, so it's not housing that's on the private rental market, but included for the first time the low-income housing tax credit properties and the USDA rural properties as well. In addition to creating an emergency transfer process that gave survivors a new option, again, not to face homelessness and to be able to stay housed, we also created a notification process so that survivors knew that they had these rights, because without having sort of a piece of paper that says, here is what happens to you if you're in a violent situation, most folks wouldn't know, and they would face the consequences. They would flee on their own, they would be evicted without knowing that that was prohibited activity. And so we really fought very hard to get a notification process included in the 2013 law. The 2013 law has been great. There's been a regulatory framework that's come out since that law. We've worked on implementation. Lots of survivors have been able to enact their VAWA rights, have not faced discrimination because of the law. But there's much more to be done that we've seen. And so that's where we stand with VAWA 2019. So next slide. So in VAWA 2019, one of the big themes for us in the housing stakeholders, and NADV is just one of those, we work with a broad group of stakeholders, was to create more options for survivors and to really clarify the roles of the housing authorities, the housing managers, landlords, the U.S. Housing and Urban Development Department, as well as the Treasury Department. We wanted to make sure that all folks who were involved really knew what they had to do, and that hasn't always been really clear, or we can see when it's being implemented that a certain stakeholder needs more education or needs a clearer guidance. So those are what we've endeavored to do in 2019. So we wanted to clarify this emergency transfer process, which is really the heart of VAWA 2013. And we wanted to make sure that folks could have a really clear sense of how that worked. In practice right now, it doesn't get implemented very quickly. So if someone approaches their housing authority or landlord or manager and says, I need an emergency transfer, and sometimes that survivor gets treated like they're asking for a transfer for some other reason, and it's not emergency. But we all know, obviously, if someone is asking to move, that really needs to happen very quickly for it to be effective at all, or they're going to have to leave and go to shelter, which again is what we're trying to avoid. So we wanted to clarify the emergency transfer process, expedite it, and also put some funds towards the emergency transfer process, create an allocated fund at the federal government that would allow survivors to transfer using a voucher, so they can move to the private rental market if where they're staying is no longer safe, and use their voucher to do so. We feel like that's a great way to make sure that the emergency transfer process actually happens. We wanted to clarify again that survivors not just be not evicted because their perpetrator is being violent, but there's other activities that perpetrators do that are criminal that evict survivors as well. So for instance, if a perpetrator is selling drugs from the premises, often a survivor is swept into that and assumed guilty and evicted as well. And what often happens is that survivors of domestic violence, and of course those survivors of trafficking, right, are coerced into activity or are not involved at all, but sort of assumed involved and get evicted. So we're trying to give landlords and owners and managers the tools to assess if the person who the other person in the relationship is indeed involved, and whether they should keep their housing, even though there's a perpetrator who's potentially dealing drugs on the premises. So that is something that survivors face all the time. And as we know, domestic violence takes all sorts of shapes, and that's often one of the shapes that the survivors are coerced into illegal activity, or illegal activity. They can't stop it, right? So we want to clarify that. want to delineate a family breakup procedure, which means that the survivor, if the perpetrator was the person who held the lease, that the survivor would have the ability to be the leaseholder, so that they wouldn't be really dependent if the perpetrator leaves for whatever reason, like goes to jail or there's an order of protection, that the survivor would be able to be the one to take over the lease and be able to stay in the apartment or the unit. We wanted to have another option is early lease termination. Lots of states have early lease termination, and that's fantastic, but we don't have it at the federal level. And again, these are programs that are federally subsidized. So this would help to make sure that survivors can leave their units quickly if they need to. They have another option. So this is some survivors are going to transfer, other survivors are going to try to stay in the lease once the perpetrator is gone. And another set of survivors altogether is going to have early lease termination, because it's all about creating additional options for survivors and their families. And we also want to make sure that those who are involved in the VAWA housing process have an enforcement mechanism. Many survivors find that their housing authorities are unable or don't correctly implement the Violence Against Women Act, and their rights under VAWA are not maintained. And so this would give survivors the ability to complain to the U.S. Department of Housing and Urban Development and find a resolution. That's what we're trying to do. Right now, there really isn't a mechanism for that. So survivors kind of go from pillar to post, and there's no one who really has a way to make sure that those who are accountable for implementing the VAWA law actually do. This would change that. One of the ways that we would do that is creating a position at the U.S. Department of Housing and Urban Development, a Violence Against Women Director position. So there's someone there at the main agency that's implementing VAWA who is in charge of making sure that the agency is fully implementing this very important but kind of complex law. So it needs someone at the helm to both be able to hear the complaints and figure out how we address actors who are not following the law, and also to promote training, technical assistance to help survivors really access their rights. Some survivors have told us that they face retaliation when they report their landlord is not following the Violence Against Women Act, and we would prohibit that explicitly and have a process by which folks would be held accountable. Finally, we want to prohibit nuisance ordinances. We want to give communities the tools to fight crime without penalizing landlords or survivors. So as it stands, if you're not familiar with a nuisance ordinance, I would Google the case of Ms. Briggs out of Norristown, Pennsylvania. She was assaulted by her ex-partner. She had to be airlifted to hospital. And when she returned from the hospital facing grave injuries, she had an eviction notice on her doorstep telling her that she had 3 strikes. The law enforcement had been out too many times. Law enforcement and emergency services had been out too many times. And now she and her 4-year-old daughter would face eviction because of that. Again, a perpetrator who she had broken up with continued to come to her apartment and be violent towards her, and she was being held accountable for that violent behavior. And so she fought her local jurisdiction and won, but many communities across the country have these nuisance ordinances that hold landlords to some standard that they're meant to evict survivors based on the criminal actions of the perpetrator, and it doesn't help landlords, it doesn't help survivors. So we're trying to make sure the Violence Against Women Act can incentivize other ways to address violent crime that doesn't indeed punish survivors once again. So those are the main things that we have in HR 1585 that we're excited to see in the Senate, and would love to have your support, as we know that you face these issues with survivors every day in terms of accessing the resources that are out there, but also the legal framework to keep them safely housed. And I would also recommend, just very quickly, that if you have any additional housing questions, that you can reach out to us at NASW. We work really closely with lots of communities to help increase access to housing resources. So we'd love to work with any of you on that as well. So thank you.
Thank you, Monica. At this time, I'd like to introduce Virginia Davis. Virginia is a senior advisor at the National Congress of American Indians. Virginia works on policy and legal issues related to violence against Native women and public safety in tribal communities. From 2009 to 2012, she served as the Deputy Director for Policy at the Office on Violence Against Women at the Department of Justice.
Great, thank you so much. I'm going to start by looking back a little bit at VAWA 2013 to set the stage for the priorities for Indian country and Native victims for this upcoming reauthorization. Just a little bit of an additional introduction of myself. As was mentioned, I work at the National Congress of American Indians. We are the organization of Indian tribal governments. So I work with tribal governments across the country. I know we have a range of folks on the call today, and some of you may be more or less familiar with the way our tribal governments operate, but there are 573 tribes across the country that are recognized by the federal government. They have their own court systems often, their own police departments, their own hospitals, their own schools. They function as the local government in many places with a unique set of laws that applies that has had a uniquely difficult and damaging impact on safety for victims of the types of crimes that are covered by VAWA. You know, every reauthorization of the Violence Against Women Act has included provisions aimed at addressing these issues. I'm going to focus on VAWA 2013, however, because it was really a historic victory where Congress took a big step forward in recognizing the need to empower tribal governments to address these crimes on their land. And in particular, that the 2013 law, which as you may have heard about as a signature piece, a signature accomplishment from VAWA 2013, recognized the tribe's inherent authority to prosecute non-Indians for crimes of domestic violence, dating violence, and criminal protection order violations that occur against Indian victims on tribal land. Next slide, please. I'm going to talk a little bit about why this was such a big priority and what the problem is that Congress was trying to get at. You can see from this slide that and this is all, these stats are all taken from an NIJ study that was released in 2016. But over, nearly 85% of American Indian and Alaska Native women experience intimate partner violence, sexual violence, or stalking in their lifetime. It's a really, kind of devastating phenomenon that's occurring in tribal communities. Over half of Native women specifically experience sexual violence, and that's important, and I've highlighted that because one of the priorities that we have for this upcoming reauthorization, and nearly 1 in 2 have been stalked. The NIJ study also found that 96% of these female victims report that they experience violence at the hands of a non-Native perpetrator. So, and that's not the norm. For most communities, what you see is that violence is predominantly interracial, but in Native communities, intraracial, but in Native communities, we are seeing a higher rate of interracial perpetration. That final slide, stat on the slide is explaining that Native women are 3 times as likely to experience sexual violence by an interracial perpetrator. So you may be wondering, well, why does that matter? If you could go to the next slide, please. Normally, obviously, we don't really care about the racial makeup between the offender and the perpetrator and the victim when we're thinking about prosecution of these crimes, but the legal framework at play in Indian country makes this very relevant. There was a Supreme Court case in 1978, U.S. v. Oliphant, where the U.S. Supreme Court held that absent congressional action, tribes could not prosecute non-Indians who commit crimes in Indian country. So since 1978, that had been the law of the land, that the tribe's exercise of criminal jurisdiction was limited to those crimes that were committed by Indians against Indians on Indian lands. When a non-Indian committed a crime against an Indian on Indian land, in most places in the country, the U.S. attorneys were responsible, the federal government was responsible for prosecuting those crimes. But what we saw and what prompted Congress to pass VAWA 2013, the tribal provisions there, was that in many, many cases, were being declined by the U.S. attorneys. They weren't taking their responsibilities to prosecute these crimes seriously. Next slide, please. The next slide, I'm not going to talk through it at all. I put this up only to show that the existing framework to establish jurisdiction in Indian country is incredibly complicated. This is really the flow chart of what you would go through trying to figure out the race of the perpetrator, the race of the victim, where the crime occurred, whether there are special laws in place, etc., before you can figure out who has the authority to investigate or prosecute the crime. And even where all of the players, the state government, the federal government, the tribal government, even where everybody wants to do the right thing, a system this complicated, it just doesn't work. And that's what we've seen in Indian country, and it's one of the main reasons why we have such high rates of perpetration. Next slide, please. Oh, sorry, that was an animation. You can just skip to the next one. So again, what Congress was trying to do in VAWA 2013 was to clean up a little bit of that mess from the last slide, but they did it in a very narrow way. So the 2013 law only reaches crimes of domestic violence, dating violence, and protection order violations. The 2013 law also made very clear that the crime has to occur within the tribe's Indian country, which is a legally defined area that we don't need to get into for purposes of this webinar. And that the victim must be a Native person, and the defendant must have sufficient ties to the community. So specifically, Congress said that the defendant needs to either live on the reservation, work on the reservation, or be in a qualifying relationship with a tribal citizen. Next slide, please. The upshot of that is because it was so narrowly drawn, while it has been incredibly impactful for some victims, we have seen the tribes have been able to make use of that law to hold serial abusers accountable for the first time and have brought safety and really just transformed safety for certain victims in Indian country. But it also leaves many victims still unprotected. So the narrowness of the VAWA 2013 provision means that tribes still can't exercise jurisdiction over non-Indians who commit child abuse or child sex abuse on their lands. That's a huge one. The tribes that have been exercising jurisdiction over non-Indians since VAWA 2013, they report that over 60% of their cases where they're prosecuting non-Indians for domestic violence offenses against their adult partners also involves children, either children as witnesses to the violence or oftentimes as victims of abuse as well. And in those cases, the tribes can only prosecute the domestic violence crime, not the child abuse crime that's occurring alongside it. We also, the rates of exposure to violence for Native children are just really devastating, and as a result, there's studies that say that Native children are experiencing rates of post-traumatic stress disorder that are equivalent to returning Iraq and Afghanistan veterans, 3 times the national average. So the fact that VAWA 2013 didn't reach Native children is a big concern for the tribe. It also leaves out stranger or acquaintance rates. Those crimes, wouldn't qualify as domestic violence, and so the tribes are unable to prosecute those crimes. Same with stalking and sex trafficking. It also doesn't cover other crimes that may be committed at the time of the domestic violence incident. And by that I mean, we had a case where the victim called 911, when she was being abused by a non-Indian. By the time the police responded, he had fled the scene. He was severely intoxicated. He crashed his car into the neighbor's fence, but the tribe couldn't charge him for the drunk driving or the destruction of property that occurred as he fled the scene, because they're limited to charging only domestic violence. And that both has an obvious public safety concern, but it also increases the pressure on the victim of domestic violence. If the offender in that case had been Indian, the prosecutor could have charged him for the full course of criminal conduct and likely could have used the drunk driving charge to help leverage a plea agreement in the domestic violence charge. But since that wasn't an option in this particular case, the prosecutor really had to put a lot of pressure on the victim to testify, which was obviously very, very difficult for her, especially given the severity of her injuries in that particular case. The VAWA 2013 bill also leaves out any crimes that may be committed within the context of the justice system. So if a non-Indian is in tribal court and he perjures himself, or he engages in witness intimidation, or as one of them did, he assaults the bailiff in the courtroom, the tribe can't hold them accountable for those crimes. Next slide, please. Next. So this is a case that I think really drives home why we need Congress to expand what they did in VAWA 2013. I'm not going to read this whole thing to you, but I wanted it to be available to you in the handout. It's the Sault Ste. Marie tribe, which is a tribe in Michigan, has implemented VAWA 2013, so they are exercising criminal jurisdiction over non-Indian domestic violence offenders. And they had a non-Indian who was in a relationship with a tribal member and moved into her home on the reservation and was making sexual advances on his girlfriend's 16-year-old daughter. So he was sending her inappropriate text messages and eventually groped her. She reported that. The tribe arrested him, and they attempted to charge him with domestic abuse because, again, that's what federal law limits their authority to, and they were trying to characterize his harassment of the daughter as a part of a pattern of abuse against the mother. But the tribal court dismissed that case. They thought that was kind of too much of a stretch under federal law. And so he moved off the reservation, and several months later he was picked up by the state for having, or by the city for having kidnapped and raped another 14-year-old tribal member. It was a really, kind of a heartbreaking case, and when we talk to the tribe about it, they say, they're just devastated that if they had been able to maintain jurisdiction and prosecute him in the first case, they think perhaps that rape of the second child could have been prevented. And it's to us, kind of really drives home the need for Congress to expand the 2013 provision and extend this really important tool for justice and safety to reach additional victims in Indian country. Next slide, please. So HR 1585 does all of these things. It attempts to fill these gaps. There's a tribal title in the bill, Title IX, it's Safety for Indian Women, and it does a number of things. There's a quick summary on this slide. It includes some important findings about the problem. Section 902 authorizes what we call the TAP, or Tribal Access Program. That's a program that DOJ administers to try and make sure that tribal law enforcement officers have access to the federal criminal information databases, which include the National Protection Order file, and all of that information sharing is really important. Section 903 includes the amendments to fill the gaps in tribal jurisdiction that I was just talking about. And Section 904 and Section 905 of HR 1585 include some additional provisions that are aimed at getting better reporting and improving the response to cases of missing or murdered Indigenous women. Next slide. I'm going to talk in more detail about Section 903. As I said, it's aimed at filling the gaps in jurisdiction that I was just talking about, and in particular, it's written so that crimes against children, sexual violence, sex trafficking, stalking, obstruction of justice, and assault of a law enforcement or correctional officer would all be prosecutable by the tribal governments, which we think will be really, really important. Next slide. Or that may be my last slide. So those are, we were very pleased to see Congress's recognition in HR 1585 of the need to do more in the jurisdictional space, we are happy to have a chance to talk to you all about it and explain why this is so important for Indian country. So thank you.
Thank you so much. Before we go on to our next presenter, I just wanted to let you guys know we're running a little bit behind, so we're going to extend it to 2:30 so we can involve some Q&A. You can enter them in the box, and we'll answer them as we can go, but we'll also leave a little time at the end for some more questions for our presenters. At this time, I'd like to introduce Emily Waters. She's a policy consultant with the Transgender Law Center, the largest national trans-led organization advocating self-determination for all people. She currently co-chairs the LGBTQ Subject Matter Committee for the National Task Force to End Sexual and Domestic Violence.
Hi, everyone. So I'm going to speak a little bit about the LGBTQ provisions of the most recent Violence Against Women Act. But before I go into that, I wanted to briefly share a few important facts about LGBTQ communities and how LGBTQ people are impacted by these types of violence, just to illustrate why these protections are so vital for our communities. So something that I'm sure you all have seen is that recent data is showing that more and more people are identifying as LGBTQ. This recent Gallup poll estimates that close to 11.5 million people in the US identify as LGBTQ, but you can see that number is steadily and quickly rising. Slide, please. We also know that more and more youth in particular are identifying as LGBTQ. Here you can see that around 8% of millennials currently identify as LGBTQ compared to 3.5% of Generation X. So obviously a lot more millennials identifying as LGBTQ. And if we actually look at more current generations, such as Generation Z, we know that that number is actually much greater. And other studies that asked folks, if they identified as something other than straight, for example, showed much higher rates, somewhere in like the 40 to 50%, which is really important when we're thinking about some of the youth provisions of the bill, as Deborah was talking about earlier, some of the expansions of the youth programming and funding, and how that would impact LGBTQ youth. Next slide, please. Something else that's important to think about, because of the ways that oppression plays out in our culture, when people hear about LGBTQ people, they often, the first image that comes to mind is a white affluent person. But we think it's really important at TLC to understand the ways that people's multiple identities and the ways that multiple oppressions show up in people's lives, particularly for survivors. So what we know from research is that actually people of color are more likely to identify as LGBTQ than white people. For example, in this slide, you'll see that nearly 6% of Latinx people identifying as LGBTQ, nearly 5% of Black people identifying as LGBTQ, compared to roughly 4% of white people. I'll emphasize this in a bit, but once again, we really just want to emphasize this so that when we talk about LGBTQ survivors, we don't erase the multiple experiences that they are experiencing when experiencing domestic violence, sexual violence, stalking, or dating violence, but then also how they show up in spaces needing to access services. Next slide, please. So in terms of sexual violence and intimate partner violence, we know that LGBTQ people experience similar, if not higher rates of intimate partner violence and sexual violence. I'm sure many of you have seen this study before and these statistics before, but what I really want to draw your attention to are the high rates of violence among bisexual communities in particular. So you'll see here that nearly 57% of bisexual women and nearly 40% of bisexual women, nearly 57% of bisexual women experience intimate partner violence and nearly 40% experience sexual violence. This is really important when we're thinking about the number of youth that are identifying as something quote unquote other than straight. They usually fall within this bisexual category. And so, as these numbers are rising for youth, it's likely that more and more youth may be experiencing these types of violence. Slide, please. So for transgender people in particular, we also know that trans folks experience really high rates of intimate partner violence and sexual violence. The data is limited. Trans folks aren't usually included in data collection systems. But what we do find from the research that we do have is that about 1 in 2 trans folks experience these types of violence over their lifetime. And this number is obviously even greater for folks who hold multiple marginalized identities. So one survey by the National Center for Transgender Equality, which is the largest survey of transgender communities in the US, demonstrated that undocumented folks, survivors with disabilities, Native survivors, multiracial and Middle Eastern transgender survivors experience some of the highest rates. And what's even more alarming is that this study also showed that despite these really high rates of experiences with domestic violence, sexual violence, stalking, and dating violence, that trans folks aren't reaching out for care and for services. So the study showed that 1% of trans survivors, 1% of trans survivors had visited or used a domestic violence shelter, a domestic violence program, rape crisis center in the past year. Slide, please. So I know I spent a little bit more time kind of laying out the importance of thinking about the full experiences of LGBTQ survivors. But I did this in order to help us understand why these provisions in the Violence Against Women Act are so important for LGBTQ folks, and how and who is most impacted by these specific protections. So many folks have already spoken on this webinar about the monumental impact of the 2013 reauthorization of the Violence Against Women Act. Same is true for LGBTQ communities. The reauthorization of the Violence Against Women Act in 2013 was actually, the changes for LGBTQ people were actually pretty simple and minor, but had a huge impact. So one of the most substantial changes was that gender identity and sexual orientation were added to the list of identities protected within the non-discrimination provisions. Additionally, LGBTQ people were listed as an underserved group. So, you know, this meant that after 2013, LGBTQ people were able to access all of the resources that people have already talked about on this webinar, and could not be discriminated against within those resources. It also meant that resources were dedicated to helping service providers, to helping law enforcement, to helping prosecutors better serve LGBTQ people. We know that discrimination doesn't go away once something's written into law, but including gender identity and sexual orientation and LGBTQ folks in the underserved category meant that resources were dedicated to helping folks better serve these communities. Slide, please. So while there's been a huge shift in the field in terms of serving LGBTQ survivors, there is still a lot of work to be done. And so that's where 1585, HR 1585 comes into play. So as Rachel already mentioned, the biggest thing that we are really working on is ensuring that those non-discrimination protections stay in place. The non-discrimination protections were put in as a reflection of the field already moving towards more inclusive practices for LGBTQ people, and we really want to make sure that the field keeps moving in that direction. Other than ensuring that the non-discrimination provisions stay in place, the changes in the bill are actually, in 1585 for LGBTQ folks, are actually pretty minor once again, and it mostly just clarifies the expectations for states in terms of meeting the non-discrimination provisions. So for example, state stop administrators have to have a plan for supporting their grantees in meeting all of the non-discrimination provisions, not just for LGBTQ folks, but all of the non-discrimination provisions. It also clarifies that state stop administrators can use the funding to provide training for LGBTQ specific trainings. Doesn't mandate it, but it just suggests that they can, which is very helpful. And then finally, we added sexual orientation and gender identity specifically to the list of the various demographic identities that colleges are required to track in terms of reports of intimate partner violence and sexual violence. Once again, this change is actually pretty minor. Colleges are already required to collect sexual orientation and gender identity information for hate crimes. So this just expands it for sexual violence and intimate partner violence. So all in all, the changes for LGBTQ folks in HR 1585 that I've already spoken about simply build on the current law to help support with the implementation and ensure that LGBTQ survivors can access services as their full selves without having to hide this important part of themselves. Slide, please.
That is it for
actually, can you go back one slide? Sorry. Okay, slide, please. And with that, I will pass it on to Lisalyn.
Thank you, Emily. At this time, I'll introduce Lisalyn. Lisalyn R. Jacobs is the CEO of Just Solutions, bringing injustice to counteract injustice, and the former VP for 13 years of government relations for Legal Momentum, formerly NOW. She advises clients on a variety of issues, including campus sexual assault, workplace and other economic protections for victims of domestic and sexual violence and stalking, racial equity, criminal justice and policy reform, and the intersections of two or more of these issues.
Good afternoon. Next slide, please. I am happy to have joined everybody this afternoon. I think I probably, in putting together my bio, left out the most important part of my identity where this work is concerned, and that is that I co-chair for the National Task Force to End Sexual and Domestic Violence, their Committee on Economic Justice, and that is the subject of my discussion this afternoon, to talk a little bit and briefly about the economic security / economic justice provisions in HR 1585. I think I'm really preaching to the choir when I explain why economic justice or economic security is so vital to survivors of violence. It's a little odd that we continue to have this discussion in 2019 about why it is that survivors don't leave their intimate partners who are abusive, and the answer is disproportionately in the economic realm, right? It's either that doing so would lead to some kind of financial or economic instability, and or that to do that would mean that they and their family would be homeless. So I'm happy to be here to talk very briefly about the provisions in this reauthorization of the Violence Against Women Act. There are about 5 of them. 2 of them are sort of more substantive, and then a couple of them have to do with research, and 1 has to do with public education. So I will run through those. As most people know, the one piece relating to economic justice that's already in law in the Violence Against Women Act is the National Resource Center on Workplace Responses to Assist Victims of Domestic and Sexual Violence, known in shorthand as the National Resource Center. It was created in 2005, and its purpose is to help employers and domestic and sexual violence advocates and survivors and labor unions and others understand how to support and respond to the needs of survivors in the context of the workplace. So Section 702 of HR 1585 does 2 important things. One is to provide more funding to the Resource Center, particularly, and we've heard it mentioned a couple of times on this call. In the Me Too era, there's an increased focus on the need for workplaces and employers to respond appropriately to issues of workplace violence and harassment, as a consequence of which the National Resource Center has really seen demand for its services and trainings rise significantly. So Section 702 of HR 1585 would increase the authorization for the Resource Center to $2 million annually. The other, and that's basically a 100% increase, because I think the cap on the authorization currently is at about 1 million. And I think they're actually being funded somewhere under that, perhaps 750,000. The bill would also do one other significant thing, and that is to make clear that the Resource Center can continue providing technical assistance and training, particularly in the area of sexual harassment. I think most people know that the Violence Against Women Act speaks to 4 crimes: domestic violence, dating violence, sexual assault, and stalking. Although the law, particularly federal law, regards sexual violence as the most severe end of a spectrum that begins with sexual harassment, the words sexual harassment actually do not appear in the Violence Against Women Act. So the reauthorization provided a good opportunity for the Resource Center to reflect on paper the work that it is already doing to try to help employers and advocates and others understand how to respond to and better support the workplace-related needs of survivors experiencing the whole panoply of sexual violence, from sexual harassment at the one end to sexual assault at the other. Next slide, please. The next provision I want to talk about is one that actually has a huge amount of traction at the state level, but for that reason, we would like to close the gap at the federal level, and that's to make sure that all survivors of domestic and sexual violence and stalking, and newly added to this is sexual harassment, are eligible to be considered for unemployment insurance. As I think many people know, unemployment insurance is really handled at the state level. Many are aware, not all, but many are aware that most states, and I think at this point it is about 40 states, and in addition, the District of Columbia, the US Virgin Islands, Puerto Rico, their unemployment insurance systems make it possible for survivors who are leaving employment, who have to quit their jobs because of sexual or domestic violence against them. In most places, you can apply for unemployment insurance on that basis. The fact that you are a survivor and leaving for that reason does not guarantee access to to unemployment insurance. There may be other reasons entirely unrelated to your experience of violence that make you not eligible. For instance, if you have not worked long enough, you haven't accumulated enough or paid enough into the unemployment insurance system. But the idea basically behind this provision is that survivors' needs do not vary when they cross state lines. So having states making an individual determination about whether or not survivors could be baseline eligible for unemployment insurance created this crazy quilt kind of situation where, like, particularly I work in the Washington, D.C. area, and people who work here come from a variety of other jurisdictions, Maryland and Virginia. D.C., for instance, makes unemployment insurance available where Virginia does not. So you could be in a workplace where you have the exact same job and sit next to someone who lives in Virginia and you live in DC, and your access to unemployment insurance based on the experience of the same kind of intimate partner violence varies wildly. So trying to close that gap, and additionally trying to provide training for folks at the state level who will be either looking at whether or not people are looking at whether or not people are eligible for unemployment insurance on the one hand, and also for TANF workers, right? What we often see is that when federal laws are passed or changed, the people whose job it is to implement them on the front lines don't get that information, don't get the kinds of training that they need. So the bill as currently drafted actually includes training provisions so that state staff and labor agencies who determine unemployment insurance eligibility, as well as state staff working on TANF, which is welfare-related issues, are aware that if someone has to leave a job because of domestic and sexual violence, that they may be eligible for unemployment insurance, and that they inform applicants for those resources accordingly. The final thing this provision would do is to enable the Secretary of Labor to create pool of funding so that someone could create model training programs to help, again, state actors in the labor departments, and where they provide TANF, which is generally the Department of a state Department of Health, excuse me, to help them understand and do the kinds of training for staff that is needed. Next slide, please. So this, as I indicated when I began, is one of several research provisions that's in the bill. This one would have the Secretary of the U.S. Department of Health and Human Services work together with the Secretary of Labor to do a study on the kinds of barriers that survivors are experiencing at the state level, and try to better understand what barriers survivors are facing in terms of maintaining economic security. Separately, this Violence Against Women Act proposal contains a definition for the first time of economic abuse. We understand that that is very much a phenomenon that's taken hold, and that many survivors are dealing with perpetrators who are trying to bankrupt them and otherwise adversely impact their economic security. So research like this, to try to understand at a state level what challenges and barriers survivors are facing when it comes to economic security, would be invaluable. The bill also requires that the Secretaries of Labor and HHS then issue recommendations about how access to economic security for survivors can be strengthened and improved. Next slide, please. So this is another study that the Title VII, which is the economic justice provision, contains. This one would require some federal research coming out of the Government Accountability Office, that research be done on economic challenges that survivors of sexual violence in the campus and domestic and dating violence in the campus context are experiencing. Because what we know is that particularly in that campus context, if someone is being victimized in the intimate partner context, that can have severe and adverse consequences for their ability to remain in school and to be able to complete their education. So the study would look at a variety of issues like the impact of the violence and how that impacts the survivor's ability to establish and maintain their financial independence from their abusers. The study would also look at things like whether or not people who take time off or maybe stop out for a semester, how that impacts them in terms of their access to or ability to maintain student loans, what the impact is if someone defaults on a student loan, what kinds of provisions exist in current law to encourage people who provide student loans to work with student survivors of violence. That's what this particular study would address, and that is a study that is supposed to be finished 18 months after this bill is signed by the president. Next slide, please. So what we also know, I think, in doing this work is that where there are economic protections at the state level for survivors, whether or not it's a state that's already providing unemployment insurance, whether or not it's a state that provides paid sick and safe days, survivors and sometimes advocates don't know that these protections are available. There are some states that also provide anti-discrimination protection, which means that survivors are not supposed to be fired solely because they are survivors. So what this provision would do would require the Secretary of the Department of Labor to identify and work with someone qualified to develop a public education program so that people who do this work as well as survivors are apprised not only of the provisions that I've been talking about, hopefully the provision that provides unemployment insurance, but also existing state level provisions to kind of help educate people writ large, because what we also understand is that when people are making determinations about whether or not they can leave an abusive relationship and they are thinking about their ability to sustain themselves economically, certainly understanding that unemployment insurance is available would be helpful. Also understanding if they are not working with a supportive or well-educated employer, understanding that they may be in a state that entitles them to take paid time off so that they can do safety planning or change locks, etc. These kinds of provisions are really life-saving for survivors, but they don't have any effect if survivors don't know that they exist and how to access them. So that really is the purpose of the public education provisions. Next slide, please. So that wraps it up for me, and I am going to turn it back to Rachel, who I think is going to give us our charge going forward. Rachel.
Hi guys, yeah, thanks Lisa. So obviously there's a reason we're holding this webinar, and that is because we need your help. Lawmakers want to hear from their constituents. They know what's important to us here at the national level and in the national organizations that do this work, but they need to know what's important to you. If they know their constituents who care about a certain issue, their constituents being the people who elect them, they're more likely to care about it too. So the House of Representatives is heading home tomorrow for the August recess, and Senate is leaving town at the end of next week. They don't come back to DC until September 9th, the week after Labor Day. So during the recess, lawmakers do a lot of in-state activities like town hall meetings and other events. They and their staff also meet one-on-one with constituents. So that's where you guys come in. You can help push VAWA forward by engaging directly with your lawmakers. Since the House has already passed HR 1585, we're focusing primarily on the Senate, but it never hurts to let your House members know that you're watching them, give them kudos for supporting it or condemn them if they did not support it. So our message to the Senate is basically the House has passed a strong bill to protect victims and survivors, and the Senate needs to do so as well. The Senate bill must have no rollbacks, and it has to be substantially similar to HR 1585. My plan was to take you through a lovely toolkit that we put together for your convenience. It looks like we are running out of time, so I'm just going to really quickly show you the pages for your convenience, but not actually go into depth anything. Could you make me show my screen, please, Pat? Thank you. All right, so there we go. Okay, so this toolkit, it will be attached in the follow-up. It's also under the handouts. It's a whole special August recess edition. You can read what's in it in the table of contents. But basically, there's information about meeting your senators, the different ways you can meet your senators. You can meet them in town hall meetings and events, which is a public forum. So whatever the senator says will be on the record, or you can meet them privately, individually, and that gives you an opportunity to go a little bit more in detail and talk about local issues, but also because you're speaking privately with either the senator or often a member of their staff, they're not taking a public position. So town hall meetings and public events, we're providing you with an optional script. If you want to ask your own question, put something together, that's absolutely great. Otherwise, feel free to use this. It's a good idea to write it down. Write down your question in advance, just in case you lose it in the moment. Here's information about meeting with your senators or their staff, information about how to set up a meeting, what a meeting will look like, some of the things you need to do to prepare. Also attached to follow-up meeting or email and in the handouts, there are a couple of fact sheets about kind of the priorities in VAWA reauthorization, and then also just kind of a myth-busting document as well. If you do have in-person meetings with either your senators or their staff, we have a wonderful checklist here for you. This is, we're giving it to you in a Word document, so you can take our logo off and put your logo on if you would like to. But this is really just kind of a checklist that's a, your member of Congress won't be publicly, expressing support or opposition to VAWA or to HR 1585, but you at least have a record, so you can put their name and ask specific questions. So do you support reauthorizing VAWA with vital enhancements and with no rollbacks? Yes or no? It gives you just also a little bit of a guide when you're having those meetings. If you have any questions, I know there was, oops, you don't need to see that. If you have any questions, I know we didn't get to them, but we can answer those following up. We really appreciate everything that you're doing, the work you do one-on-one with victims and survivors, and we also really appreciate your help in moving VAWA forward.
Thank you so much, Rachel. This is Suzanne again. At this time, I'd just like to let everybody know, since we're running out of time, that we do have a few questions. Any other questions that the attendees have, if you can email them to us at mainoffice@ncadv.org, we can disseminate those to the panelists and get those ready. We will also answer any other questions that you have via email as well. I'll ask these couple questions we have to our panelists. One of the ones we have in regards to the tribal information, who exactly controls the statistical information for tribes? Some major laws were just changed for Native American women, considering they are sovereign nations. I'm not sure if Virginia is available to answer those.
Sure, I'm here. I'm not sure I quite understand the question. So the question was, who controls the statistical?
Yeah, who controls the statistical information for tribes, considering they are sovereign nations?
Yeah, so it's tricky. And so, I'm going to answer a question. I hope it's the question the questioner was trying to put forward. But, getting good information about victimization or about crimes or the criminal justice system in Indian country is notoriously really challenging. And in part, that's because of the split in jurisdictional responsibilities that I was just talking about. So if you were trying to figure out like the crime rate based on, police report kind of data, you would need to aggregate information from the tribe, from the state, and from the federal government. And the state and the federal government don't necessarily track tribal citizenship of the victim or the offender. So it's really difficult to get accurate kind of crime information. That's leaving aside the whole question about whether or not, obviously police reported crime data is a good source of, it's obviously very different than victimization data, right? Because a lot of crime doesn't get reported in the first place. And in terms of a victimization survey, a tribe could conduct one on their own lands or among their own citizens, or, the stats that I put up were taken from the NASW, which is the National Intimate Partner and Sexual Violence Survey that I think the CDC administers. And that's the big nationwide victimization survey that's trying to get a sense of victimization rates across the country. And they did, this starts to get technical, and I'm happy to follow up with anybody who's particularly interested, but when they did the NASW in the early, 2010, 2011, they did an oversample from Indian reservations so that they would be able to, have better data to try and give us a better picture of victimization rates on Indian lands. But yeah, so tribes are producing some criminal justice data, but to the extent that other sovereigns, the state and the federal government, also share jurisdiction on tribal lands, they would also have some of the information. So it's a very tricky thing to get good, accurate data in this space.
Okay, thank you, Virginia. That cleared it up. Also, We had a few people requesting a URL to your graphic. So if we can get that from Virginia, I will send that out in the post-webinar information along with the handouts and certificates of participation. I think we're going to wrap stuff up right now. We'll wrap stuff up right now. Any other questions that we have, we will email out answers. And at this time, I'd just like to, on behalf of NCADV, thank all of our presenters today for a very informative webinar. And thank you to our audience for sticking around with us and for all of your participation and engagement throughout this webinar. Thank you so much, everybody. Have a great afternoon.